Good afternoon, everyone. I would like to welcome all of you to Dakota Dilemmas, Navigating the Complaint Process. Thank you all for taking time from your schedules to join us today and continuing learning about ethics laws through this Dakota Dilemmas webinar series. I want to especially thank all of you who joined us for our earlier webinar sessions in March and April. I am Rebecca Binstock, and I have the privilege to serve as the Executive Director for the North Dakota Ethics Commission. With me today is Logan Carpenter, who serves as General Counsel for the Commission. Mr. Carpenter and I will be co-hosting our webinar today. The Commission's Dakota Dilemmas webinar series was created for the purpose of educating not only the public, but also state officials about the Commission and how it meets its constitutional obligations. During our first webinar in March, we explored a historical perspective of ethical conflicts in our state, starting with even prior to statehood. During our second webinar in April, we learned how to manage conflicts of interest that inevitably arise throughout our state's work. I want to add that both of these previous webinars are available both on our YouTube channel as well as under the Education tab on the Commission's website. Today, we will continue our exploration of ethics laws in North Dakota by shifting our focus slightly and navigating the Commission's complaint process. The Commission's complaint process is not well known due to the confidential nature of the process. But public citizens, state employees, law enforcement, and lobbyists alike all have presented our staff with questions about the process and how the process impacts their work. With many questions, the Commission wanted to create an opportunity to thoroughly review the complaint process and answer those questions. However, we wanted to do it in a setting that wasn't related to a specific complaint, more in a general sense. So with that, we have our topic today, and let us turn to that. Let us turn to navigating the Ethics Commission's complaint process. As before that we've done with our previous webinars, if you have questions along the way, please don't hesitate to drop those in the chat, and we will circle back with them during our question and answer portion at the end of the webinar. Unlike previous webinars, we do not have any survey questions today, so don't look for those. All right, let's dig in. Our focus today is on the Commission's process for receiving and investigating complaints. Article 14 of the North Dakota Constitution, which you will hear a lot about today again, directs the Ethics Commission to, quote, investigate alleged violations, end quote, of state law related to transparency, corruption, elections, and lobbying by certain group of individuals, lobbyists, public officials, and candidates for public office. In 2019, prior to the commissioners being appointed on the commission, the 66th Legislative Assembly codified a complaint process for the Ethics Commission to follow when it receives an allegation of a violation of state law. Today, we will cover how a complaint is filed, how a complaint is processed and investigated by the commission, from the beginning where we receive it all the way through resolution. We're also going to talk about the roles of the complainant, the respondent. It's okay if you don't know what those terms are right now. We're going to get to that. And the commission along the way. So let's take a brief look at our agenda for today. Our presentation, our webinar, is broken into 5 sections today. Some of these, if you previously tuned in to our other webinars, we're going to review those just briefly, and then we're going to get into the crux of our presentation. So our first section today, we're going to talk about North Dakota Constitution, Article 14. This is where the Ethics Commission derives its investigatory authority. So we're going to start by looking at the language of Article 14. We're also going to then move on and discuss the complaint process developed by the Legislative Assembly and is in statute, and the process that's been developed by the Ethics Commission in its rules. We're then going to move on in Section 3, the filing of complaints, and discuss who can file a complaint with the Ethics Commission and how individuals go about doing that. It's a really practical step that we need to talk about. 4, this is going to be the big area and what we really want to focus on today. 4 is walking through the 3-step process the Commission follows to process and investigate complaints. This is the process that the Commission follows with every complaint that it receives. And last, Section 5 is complaint resolution. We're going to touch on what happens after the investigation is complete and the Commission has made findings. What happens from there? So this is our agenda for today. So we're going to go ahead and get started. So we're going to start our session with a little bit of a recap. So I know that in previous webinars, we've talked about the creation of Article 14, and we're going to do so again today because at the end of this year or at the end or at some point in the future, the Commission really wants to have this information out there about how it was established that it's a constitutional entity, and we want to be sure you guys know this. So we're gonna talk about it briefly. It also is the source of where everything, all the authority for the Ethics Commission flows, so it's very important. So a citizen-initiated ballot measure was sponsored by North Dakotans for Public Integrity in 2018 and put Measure 1 on the general election ballot in November of that year. This measure, Measure 1, established a state ethics commission in North Dakota. Voters approved the measure, with it passing by a 54 to 46% margin. This therefore created Article 14 of the North Dakota Constitution. North Dakota joins 47 other states, so a supermajority of states, with an independent ethics commission or equivalent. Only 2 states don't have an office dealing with ethics. Those 2 states, I've already talked about this previously, is Idaho and Wyoming. Now we have the Constitution. Now we have that follow-up. In 2019, during the 66th legislative session, the legislature passes enabling legislation for the Commission that sets out the complaint procedure for the Commission. We're going to talk obviously about this in quite a bit of detail later. In 2019, that legislation also outlines and creates certain penalties that Article 14 of the Constitution required the legislature to create. This included penalties for lobbyist gifts, lobbying by public officials, and for lobbyists delivering campaign contributions. After the 66th legislative session in 2019, so in later 2019, the Commission's members were first appointed. Now, the Constitution requires that 5 members serve on the Commission, and these members be appointed by consensus agreement of the Governor, Senate Majority Leader, and Senate Minority Leader. Commissioners cannot be other state public officials. They can also not be lobbyists. All of the current commissioners are the original 5 commissioners that have been reappointed. Each of them is now in their 2nd term. Those 5 commissioners are Chair Paul Richard of Fargo, Vice Chair Dave Anderson of Bismarck, Commissioner Ron Goodman from Oaks. Commissioner Goodman also served as the first chair for the commission in 2019. Commissioner Dr. Cynthia Lindquist of St. Michael, and Commissioner Ward Kozer of Williston. If you notice, we have coverage all over the state, which is very nice. In 2019, the 5 commissioners also established a mission for the North Dakota Ethics Commission, and that is to strengthen the confidence of the citizens of North Dakota in their government by ensuring and promoting transparency and accountability. So now let's go back to Article 14 of the Constitution. Under Article 14, the Ethics Commission has constitutional authority to do 2 things. 1, it has authority to adopt ethics rules related to what we call our 4 buckets: transparency, corruption, elections, and lobbying, to which any lobbyist, public official, or candidate for public office shall be subject to. The second directive the Ethics Commission gets is a directive to investigate alleged violations of the Commission's rules, Article 14 of the Constitution, and related state laws. So the Commission really has 2 constitutional directives. 1, we're going to talk about in great detail, which is that investigative piece. The other one is this adoption of rules. And the Commission then can therefore investigate the rules that it adopts. So we're going to briefly touch on these rules that have been so far created. The Commission has established rules related to the complaint process, which we're going to talk about, lobbyist gifts, the appearance of bias that can happen in quasi-judicial proceedings, and conflicts of interest. When the Commission was first established in 2019, they first took on the task of creating rules related to the complaint process. Those rules were adopted in 2020. They're the longest standing set of rules. They've since been amended a few times to simplify or to clarify the process. These rules describe the process for filing and investigating a complaint, and it is the focus of our webinar today. Also in 2020, the Commission adopted lobbyist anti-gifting rules. This describes the prohibited gifts between lobbyists and public officials, as well as the exceptions to that prohibition on gifts. Then in 2022, the Commission adopts an additional 2 sets of rules. The first one is the appearance of bias rules. These rules address appearances of bias in quasi-judicial proceedings. So quasi-judicial proceedings are those proceedings that are not judicial proceedings or in court, but they happen mostly in administrative agencies. The Commission also adopted in October of 2022, conflict of interest rules that help to manage potential conflicts of interest that inevitably happen for public officials. The Commission is also currently discussing and considering draft financial and travel disclosure statement rules for public officials. It is part of the Commission's strategic initiative to continue to work with entities that their rules impact and ensure understanding and uniformity. It's one of the reasons that we're here today. So let's start talking about this first set of rules, which is the complaint process. Now, before we get into the nuts and bolts of the complaint process, let's discuss this very important step of personal jurisdiction. This is who the Commission can receive complaints against. The Ethics Commission has authority pursuant to the Constitution over lobbyists, public officials, and candidates for public office. So we have those 3 groups. We can then further define public officials. Public officials includes elected officials or elected individuals, statewide elected individuals, appointed individuals, in both the executive and legislative branches. Members of the Ethics Commission, as well as Ethics Commission staff, and legislative employees. Who is not included as a public official is the judicial branch or executive branch employees, unless the executive branch employee is appointed. And there are some of those individuals who are executive branch employees but are appointed. For complaints involving quasi-judicial proceedings, Article 14 of the Constitution granted the Commission a somewhat expanded authority over people or over persons. So it's a slightly expanded personal jurisdiction. The authority here under quasi-judicial proceedings covers directors, officers, commissioners, heads, or other executives of agencies who take part in the quasi-judicial proceeding. This could potentially include a non-appointed executive branch employee if he or she is acting as a director, officer, commissioner, head, or other executive in the quasi-judicial proceeding. Now, the Ethics Commission can only consider complaints against these individuals: lobbyists, public officials, and candidates for public office. So as we work through the complaint process, you'll see how the Commission considers this question of personal jurisdiction. There are also a few terms, two in particular, that we'd like to go over and that you're going to hear myself and Logan say several times today. So these terms come up in the complaint process frequently. So we have the term complainant. This is the person who files a complaint with the Ethics Commission against another individual. The person who files or provides information to the Ethics Commission. We also use the term respondent in Ethics Commission rules and in practice and in communications. This is the person against whom a complaint is filed. They may be accused of an ethical violation, and we use the word respondent to describe that person. However, respondent is not used in statute. The term used in statute for respondent is accused individual. But the Ethics Commission has moved away from using this term in its rules and in practice and uses the term respondent instead. So remember, complainant is the one who brings the complaint, who files the complaint, and a respondent is the one who is responding to the complaint. So as we talk about the complaint process, those terms are very important. We also have some statutory requirements for the complaint process. Article 14 of the Constitution directs the Commission to investigate alleged violations. But before the Commission was appointed in 2019 during the 66th Legislative Assembly, the legislature created this complaint process, and there are certain requirements in that complaint process that were put in by the legislature. The process developed by the Legislative Assembly has the Ethics Commission receive complaints, process them, investigate them if necessary, and ultimately determine if an ethical violation has occurred. This is the starting point of our three-step process that Logan will talk about shortly. Here are some other statutory requirements that we're going to note. Under these statutes, the Ethics Commission needs a filed complaint before it can begin looking into an alleged violation. The Ethics Commission cannot on its own go investigate an alleged violation. It needs a complaint to do that. Also under the statute, only certain individuals can file complaints. There are three groups or three classifications of individuals who can file complaints. One is North Dakota residents. Two are individuals who are licensed by a state agency, for instance, a board or a commission, or another public official who issues a license that is subject to the authority of the commission, or any party to a state quasi-judicial proceeding. So there are limitations on the individuals who can file complaints, and we need a complaint, or the commission needs a complaint to initiate an investigation. The other thing to keep in mind that is from a statutory perspective or a statutory requirement is that almost everything related to complaints is confidential under the Ethics Commission until the Ethics Commission determines a violation has occurred and the respondent has had a chance to appeal. This confidentiality portion of the complaint process is extremely important, and we want to talk about it today. So this kind of is an umbrella overview before we get into the nuts and bolts. So the confidentiality provisions that apply to the Ethics Commission complaints are a little bit complicated and can be difficult for people who are new to the process to understand. And most people are new to the process. So we want to walk through this. Under North Dakota Century Code 546612, 3 groups of information are confidential in the Commission's complaint process. 1 is information revealing the content of a complaint. This includes the identity of the complainant that's contained within the complaint. 2 is information that reasonably may be used to identify the respondent. This is the person against whom the complaint is made. And 3 is information related to or created as part of an investigation of a complaint. That is a fairly broad category. However, this information may be disclosed if it's required by law or as necessary to conduct an investigation arising from a complaint. These 3 groups or types of information retain their confidential status until and unless the Commission has determined an ethical violation has occurred and the respondent has appealed or has had a chance to appeal. Because of these confidentiality requirements, the Ethics Commission cannot confirm if a complaint has been filed with it or divulge any identifying information related to a complaint unless it is part of the Commission's investigation. I do want to note that all discussions at Ethics Commission meetings of pending complaints takes place in executive session because of the confidential nature of that. The complainant also has the option when he or she files a complaint to remain confidential, not just from the public, but from the respondent. If the complainant elects this option, meaning they remain confidential with their identity not disclosed to the respondent, the Commission cannot disclose the identity of the complainant to the respondent. There is an exception to this, however, if the complainant waives confidentiality at some point in the proceedings, authorizes its disclosure, authorizes the disclosure of his or her identity, or divulges information that reasonably would identify the complainant. The Ethics Commission may also disclose this information if required by law or if it is necessary to conduct an investigation that arises from the complaint. Now, a confidential complainant, so somebody who has chosen to remain confidential from the respondent, their identity will remain confidential even if the Ethics Commission finds the respondent engaged in an ethical violation. Another important note here is that the Ethics Commission often needs to share confidential information with other public entities. In North Dakota, under North Dakota Century Code 440418.10, subsection 5, just for you attorneys out there who are looking for the citation, confidential records that are authorized by law to be disclosed to another entity continue to be confidential in the possession of the receiving entity, except if otherwise provided by law. This statute, therefore, requires public entities that receive information related to an Ethics Commission investigation or complaint to maintain its confidentiality. So what happens if a person divulges confidential information related to an Ethics Commission complaint without an exception applying? There is a criminal statute that may apply. North Dakota Century Code 12.1 13-01 makes it a Class C felony to disclose confidential information that's been provided to government officials. So with that kind of backdrop, an umbrella kind of overview of the big things, let's get into the nuts and bolts with Logan about filing a complaint and the complaint process.
Thank you, Rebecca. So let's start off with filing a complaint with the commission. An individual can file a complaint with the Ethics Commission 4 different ways: by phone. Article 14, Section 3 of the North Dakota Constitution requires the commission to, quote, maintain a confidential whistleblower hotline. The second way you can file a complaint is in writing, either through mail or email. Third, in person. Or 4, this is coming soon. On our website, you will be able to fill out the complaint form and submit it online. Currently, the commission has a complaint form still available on our website, and it walks you through the information required to submit the complaint. Right now, though, however, you are required to email or mail the completed complaint form once you're done with it. Again, soon you will be able to do that all online and submit the form directly on our website. The Commission's confidential hotline number, as required by the state constitution, is 701-328-6000. The Commission also maintains a corresponding email for this hotline requirement, and that email address is ethicshotline@nd.gov. Again, when we're talking about people who can file a complaint under North Dakota Century Code Section 546601 sub 2, only 3 groups of people can file those complaints. The first being North Dakota residents, the second, individuals licensed by a state agency or another public official subject to the authority of the Ethics Commission, or the third group, a party to a state quasi-judicial proceeding. So now that a complaint has been filed or somebody files a complaint, let's turn to the complaint process itself. The process created by the Legislative Assembly in 2019 can be summarized in 3 steps. Step 1, initial review. Step 2, informal resolution. And step 3, investigation and commission action. The commission has adopted the same process within its complaint rules, and you can find that in North Dakota Administrative Code Chapter 115-02-01, and it is substantially the same process that is in statute with some nuances to it. A complaint may resolve at each step in the process. However, if it does not at step 1 or step 2, for example, it will move along in the process to the next step. The commission does not take a position on the matters presented in the complaint until the final step in step 3, where the commission is taking action on the complaint. The commission is required by statute and its own rules to notify a respondent within 30 days that a complaint has been filed against the respondent. So let's turn to step 1. At step 1, commission staff initially reviews a complaint to determine 2 main things. First, if the commission has authority over the respondent. This is referred to as the commission's personal jurisdiction. And second, if the commission has authority over the conduct alleged in the complaint. This is the commission's subject matter jurisdiction. Under North Dakota Century Code, Section 54-66-05, the Ethics Commission can summarily dismiss a complaint at step 1 if it 1. Does not fall within the Commission's jurisdiction, 2. Is insufficient to identify a possible violation, or 3. Fails to comply with rules adopted by the Commission. In the complaint rules, the Ethics Commission delegated the authority to summarily dismiss complaints to the Executive Director of the Commission. In practice, the Commission directs the Executive Director to summarily dismiss complaints. To initially review a complaint, Commission staff review the information submitted with the complaint, publicly available information, and other information upon request if it's needed for that initial review. So for the lawyers online today, this process is similar to a court reviewing a motion to dismiss under a Rule of Civil Procedure 12b6 standard. Commission staff look for specific facts when assumed to be true, plausibly creating an ethics violation or a violation of other state law related to transparency, corruption, elections, or lobbying. Under the Commission's rules, if the complaint is summarily dismissed, the complainant has 30 days from notice of summary dismissal to appeal the summary dismissal to the full Commission. Both the complainant and the respondent may submit additional information and legal arguments regarding the appeal to the Commission. The Commission may then vote to reopen the complaint or deny the appeal. So if a complaint is not summarily dismissed, what happens next? Well, it'll move to step 2 in the process, which is informal resolution. At this stage, the Commission must offer the complainant and the respondent an opportunity to informally resolve the complaint, meaning settle the complaint. If either party does not want to engage in informal resolution, the complaint moves to the next step in the process. The respondent is also provided a copy of the complaint or a written summary of the complaint at this stage in step 2. The respondent may then respond to the allegations in writing within 30 days if he or she wishes, but he or she is not required to respond to those allegations in the complaint at the time. The informal resolution process begins when Commission staff send both the complainant and the respondent a form to fill out regarding informal resolution. On that form, it asks whether the individual, the complainant, or the respondent wishes to engage in informal resolution. It also requests some logistical information, like scheduling, whether the complainant or respondent would be open to having an informal resolution conference virtually, and whether any issues exist that may prevent informal resolution. The form also requests what the complainant and the respondent both believe a reasonable resolution of the complaint would be. These forms are not shared from the complainant to the respondent. They don't see what each other puts on the form. It is for Commission staff to use when conducting the informal resolution. Commission staff will then conduct the informal resolution, acting as a third-party neutral. The Commission does not take a stance on the substance or a side when doing the informal resolution process. It is between the complainant and the respondent. The informal resolution process can take place in a variety of ways. Examples include going back and forth with the parties through formal written communication, speaking with both parties either in person or on the phone, having a formal mediation conference in person in a conference room, or having an electronic mediation conference online via Teams or Zoom or another platform. However, if the complaint is confidential, it complicates having a face-to-face in-person conference. Commission staff will then act as a go-between for the complainant and the respondent, communicating the respective sides' positions without revealing the identity of the complainant. The process can take a few months when it's a confidential complainant or when it's through written position statements and you're not directly speaking with the parties. Both parties may also be accompanied by legal counsel in any informal resolution proceedings. If informal resolution is successful, commission staff will have the parties sign a settlement agreement. The complaint is then automatically closed. The complaint and the informal resolution remain confidential once that informal resolution is reached, unless the parties agreed to some form of confidentiality waiver as part of that settlement. If informal resolution is unsuccessful, or if the complainant or respondent does not wish to engage in informal resolution or wishes to proceed at any point in the process, the complaint will move to step 3. So let's talk about step 3, the biggest step in the process: investigation. Article 14 of the North Dakota Constitution directs the Commission to investigate alleged violations of the Commission's rules, Article 14, and related state laws regarding transparency, corruption, elections, and lobbying. At this step, step 3, the Commission initiates this constitutional directive to investigate. The complainant no longer plays a role in the complaint process once it proceeds to an investigation. The Commission solely takes over at this point. North Dakota Century Code Section 54-66-08 states the Commission may have its staff investigate the allegations in a complaint or engage an outside investigator to investigate. The Commission's complaint rules state, quote, "The executive director shall determine the manner in which the complaint will be investigated," unquote. The executive director can also refer the matter to an outside attorney or investigator with the approval of the Commission under its rules. North Dakota Century Code Section 54-66-08 sub 3 states, quote, "The Commission may require the testimony of a witness or the production of a book, record, document, data, or other object at any of the Commission's investigator interviews or proceedings held in connection with the investigation of a complaint," unquote. The Commission often requests individuals make themselves available for interviews and provide documents. It is important to note the authority of the Commission to request interviews, documents, records, or other evidence is not an open records request. Commission requests exist outside that process under Article 14 of the North Dakota Constitution and North Dakota Century Code Section 54-66-08 subsection 3. If the Commission requests confidential records from another government entity, the Commission is required to keep those records confidential when they are received under state law, and that section is 4404-18.10 subsection 5. So what does an investigation by the Commission include? The Commission's rules give descriptions and examples of what an investigation may entail. It may include review of any documents provided to the Commission by the complainant or the respondent, review of publicly available documents or documents maintained by the state, a request for documents from individuals or entities with knowledge or relevant information, written interrogatories, which are questions submitted to individuals or entities with knowledge or relevant information, interviews with legislators, employees, or other appointed or elected officials, interviews with the complainant and individuals identified by the complainant as having knowledge or relevant information, interviews with the respondent, and any other information deemed relevant during the investigation process. So let's take a quick detour because at this point, it is important to discuss how the Commission handles complaints that contain allegations of criminal conduct. The Commission has the authority to investigate, which you hear me say again and again, alleged violations of any state law related to transparency, corruption, elections, and lobbying. Because of this broad directive, criminal statutes in those 4 areas do exist. In North Dakota Century Code Section 54-66-08, The legislature created a process for the commission to follow when complaints make allegations of criminal violations. I'm going to read the statute to you. It's pretty long, so bear with me. The statute states, quote, if the commission believes a complaint contains allegations of criminal conduct, the matter must be coordinated with the appropriate law enforcement agency with jurisdiction over the offense. If the law enforcement agency agrees to accept a referral for possible criminal prosecution, the commission may not take further action on the complaint until the law enforcement agency informs the commission law enforcement proceedings regarding the complaint are complete. If the law enforcement agency declines a referral for prosecution, the commission may investigate the complaint under the rules adopted by the commission, unquote. There are 3 important notes regarding this statute. First, the commission must form a belief there are allegations of criminal conduct before it refers a matter for criminal review. A complaint cannot merely speculate criminal conduct took place. There must be enough for the commission to form a belief of a criminal allegation based in fact. Because of this, the commission may need to reassess a complaint as it works through it. Additional information may come to light throughout the 3-step process regarding a potential criminal violation. The second thing to note, if the commission forms a belief the complaint contains allegations of criminal conduct at any time, it has no discretion and must refer a matter to law enforcement. Third, once the criminal review and/or prosecution process has completed, the complaint is turned back over to the Ethics Commission for further review and investigation if needed. So let's jump back into the commission's process, assuming it did not need to refer the matter for criminal review, or if it did, that process has completed. At the end of the commission's investigation, the executive director will prepare a report and recommendation for the commission. It is important for us to note no complaint has yet reached this part of the process. However, as complaint numbers continue to rise, the commission will eventually reach this part of the process. The report prepared by the executive director will summarize the investigation's findings and incorporate any findings by outside counsel or an investigator if one was used for the investigation. The report will also include any relevant information by reference or attachment found throughout the investigation, and the executive director will also provide the commission a recommendation on how to act on the complaint. At least 10 days before the commission considers the report and recommendation at a meeting, the report and recommendation is provided to the respondent. The respondent may submit a written response 5 days before the meeting or respond in person during an executive session at the meeting. The respondent can submit their response more than 5 days in advance to it. It just has to be in 5 days before the meeting. The respondent may be represented by counsel. The commission then deliberates an executive session regarding the complaint and the report and recommendation by the executive director. The commission determines if a violation of its rules or other law regarding transparency, corruption, elections, and lobbying has taken place. The commission also determines if a violation occurred, what penalty to impose if authorized to do so. The commission may also refer the matter to another entity with enforcement authority over the violation. The respondent is informed of the commission's decision after it makes one. So let's turn to what happens after the commission makes its decision. Following a determination an ethical violation occurred, a respondent has the ability to appeal the commission's finding to the district court where he or she is a resident under North Dakota Century Code Section 54-66-10. If the respondent does not appeal or the court affirms the commission's findings, the finding is no longer a confidential record under North Dakota Century Code Section 54-66-12. The commission will then make its finding of an ethical violation public. So with that, we'll ask you to put any questions in the chat. And I think before we take questions, Rebecca has some other thoughts she wants to share with you, so we will let her do that.
All right, so we already have some great questions going on in the chat, some that Logan and I have encountered before, so or that we've had ourselves. So keep those coming. But I'm going to give you guys just before we take questions, I wanted to let you know some logistical things so that we don't forget, because we always forget, or not always, sometimes do. That the webinar that we have today that we walked through, this is going to be available on the commission's website, as well as our YouTube channel at ND Ethics Commission. That's our handle on YouTube. By the end of tomorrow is the projection. We do have a commission meeting tomorrow, so it might be Thursday potentially. You will also receive an email from us with the slide deck later this week. I also want to share with everybody out there that we do have an opening coming on the commission later this year. A commissioner is going to be wrapping up his service, and I want to encourage anybody who's interested in serving on the commission to apply or reach out to our office with logistical questions. The application process does not go through the Ethics Commission. It goes through the governor's office. And so we will be sure to include a link to apply to serve on the commission in our follow-up email with the slide deck. As I said, everything is going to be available by tomorrow. So let's get to some of the questions that we got. So how we've done this in the past, and I think it's worked well, is I've kind of grilled Logan on the questions. I've served as your surrogate for the question asking. So I'm going to do that today. Are you ready?
We'll see.
We'll see. All right. So what are the applicable North Dakota century codes that are North Dakota century code sections which were created after Article 14 of the Constitution? So I'm assuming they're talking about in 2019, but can you let us know?
Yeah, so we included the main chapter in one of the earlier slides, and that's chapter 54-66. I believe it's entitled State Government Ethics. That's where you'll find most of the pieces that deal, if not all, but most of the pieces that deal with the Ethics Commission and our complaint process.
There we go. Okay. Another great question is, do legislative council employees, they reference behavior and actions, need to follow the rules of the Ethics Commission?
Yes, so when Article 14 was approved by the voters, the language of that article included legislative employees, which would be legislative council, in the definition of a public official.
So that's, yes.
They're subject to the authority of the Ethics Commission.
Pursuant to the Constitution and the language of the Constitution.
Yes, pursuant to the constitutional language.
Yep. Okay. So then another question. Now this is a little bit of a nuanced question. That's not my computer. But this is one that I had when I first started serving as executive director. So when does the respondent, this is a two-part, maybe multi-part question.
Okay.
I'm making him nervous, but he shouldn't be. When does the respondent receive notice of the complaint?
So the statute requires the respondent to receive notice that a complaint has been filed within 30 days. So they will receive a letter from the commission staff within 30 days that complaint has been filed.
So here's the follow-up question that I also had in my mind, and we're going to answer. If during the initial review, the commission determines there's no jurisdiction and the complainant does not appeal, is there an instance where the respondent basically becomes unaware that a complaint is filed?
No, so they will be notified at the end of the initial review what happened with the complaint, whether it was summarily dismissed or if it's moving along into informal resolution. So they're notified it has been dismissed, both the complainant and the respondent. If the complainant appeals, they will also be notified again that the complainant has appealed. Mm-hmm. They're provided an opportunity to respond in support or to address the appeal. No, don't grant the appeal if you're the respondent. And then they will be also informed of the commission's decision, whether it affirms the summary dismissal or it reopens the complaint.
Mhm. So there was actually, I'm going to give a little historical context. Before the 2023 legislative session, this notice provision and about whether it applied when the commission summarily dismissed a complaint, it was really unclear in the statute. So what we did is the commission worked with the legislature and we amended that particular portion of the statute to add in the requirement that the commission is required to notify somebody, as Logan said, that there was a complaint filed against you, but it was summarily dismissed. It's also the reason we changed the initial notice period from 20 days to 30 days, because there are instances, or there were instances, where we would quickly notify somebody that there was a complaint filed against them, and then it was also quickly summarily dismissed. So we wanted to make that more efficient for Ethics Commission staff. We also wanted to make it less anxiety inducing for those people who were getting these letters or who had gotten them. So what we did is we extended the period from 20 days to 30 days so that we could initially review it and in some instances dismiss it, and then notify them that it happened, give them a copy or a summary of the complaint and say, hey, we already took care of this, but you still deserve to know that. So that was a good move forward in 2023 by the legislature, that they included that in the statute. So there's some questions about confidentiality, and we get confidentiality questions frequently. This is one of the probably more significant questions that we get at the commission. And it says, I'm surprised about the strict confidentiality rules. So specifically, when there is talking about an accused rights to due process and an accused rights to confront or to cross-examine a complainant. So do you want to speak to that briefly?
Sure.
I can as well, but let's talk about that.
So they're talking about the Sixth Amendment right to confront a witness. That applies in the criminal context, which is not the Ethics Commission's process. If you remember, if we have a criminal allegation, we have to refer it, and then whatever happens in that process, the Sixth Amendment would apply to a witness in that process. But when we're talking about the commission's process, the Sixth Amendment right to confront does not apply, but there is a statute that says if that confidential complainant includes information or evidence, we cannot use that as evidence of a violation against the respondent unless they reveal their identity. So we have a glimpse of that, but it's not the Sixth Amendment right attaching in the Ethics Commission process because it's outside the criminal scope.
So the confrontation clause doesn't apply in the scope of our investigations.
Correct.
There we go. Okay. So then the other kind of follow up to this is, how about when we have a frivolous complaint then and somebody wants to maintain their confidentiality? How do we kind of ensure that we don't have those frivolous complaints brought by anonymous individuals that are then, proceeding through the process? How do we have that check on that frivolous nature?
So a lot of that check happens in step one when we do the initial review. If there's some frivolous nature to it, or it doesn't pass muster on the initial review, it'll be summarily dismissed and won't move forward.
So the process that's been put in place has been put in place in order to address frivolous complaints.
Yes. So we're not investigating or mediating through informal resolution something that is frivolous.
Yeah. But we still notify people just in case.
Still notify you that it's been filed.
And then somebody then asked just kind of more in general about confidentiality, if we can touch on it just kind of once again about the things that are confidential and how, and maybe when that information does eventually come out.
Yes.
So I'm going to go back up to the 3 things, and we're going to just touch on those briefly again.
Yes. So most information that would reveal the nature of the complaint or who's involved is confidential. So that's information revealing the contents of the complaint, including the identity of the complainant, information that may be used to identify the respondent, or this is the broadest one, information relating to or created as part of an investigation of a complaint. So any action the commission or the commission staff takes during that investigation that will reveal what the complaint's about, who's involved, what the commission is doing to investigate it, who they're talking to, that's all confidential. However, the commission can disclose it as required by any law that will require us to disclose it, or as necessary to conduct that investigation. So when we're talking to witnesses, we can give them some information to give them some context for what we're asking or what we're requesting. That information will stay confidential until the very end of the complaint, once the commission issues its findings that an ethical violation occurred. If the commission finds no ethical violation occurred, all of that remains confidential. And then the respondent has that opportunity to appeal. If they don't, or if the court affirms it, then it becomes open and public.
Okay, great. So there's a follow-up question to that.
Okay.
And it is somebody from Missouri, and they say that it's very common here for complainants to go to the media and release the complaint that they have filed. So in North Dakota, are the complainants, we've talked about how the commission is bound by confidentiality, are the complainants bound by confidentiality?
That's a very good question. So if you look at that criminal statute that applies for releasing confidential information, I believe it uses the term public servant. So it applies to anybody who meets the definition of a public servant. So if you don't serve in government, you're probably not going to meet that definition, and you're not bound by the same criminal penalties that would apply to somebody working for the state or another public entity.
So then the complainant, if they are not a public servant, are not bound by that confidentiality.
Potentially, yes.
Potentially, yes. That's a great question. Something that we are aware of in North Dakota that does happen as well. So we're hoping to address that. And with that, unless there are any more questions that anybody wants to quick fire at us in the chat, we're going to do a wrap up on the complaint process. Again, we want to thank you guys for joining us today to learn about the commission along with us. We enjoy doing these webinars to get information out there. You can continue to look for information on our upcoming educational opportunities. We're going to be doing some of these again, maybe in a little bit of a different format before legislative session, which is coming up fast in January. So you can look for educational opportunities, including webinars or other information on our social media and our website. You can also jump on our website and sign up for our newsletter and our mailing list so that you receive continual updates from the commission. So again, if you have any other questions, go ahead, feel free to pop them in the chat. I'll give you guys just one more minute. But thank you again. It doesn't look like anything's coming in. And we will see you guys all again soon. Thank you.